Joyce Cullen. I'm a litigation partner at Brodies and I regularly give advice to commercial clients about arbitration. Arbitration is a process where parties agree that a dispute which they have, usually over a contract, will be decided by an arbitrator who is picked by them for their expertise in a particular area or sector. Mediation and arbitration are both processes of resolving disputes, but in mediation the parties are trying to agree the dispute themselves. They have the assistance of a mediator to help them reach an agreement, whereas in arbitration the parties have come to the conclusion they can't reach agreement themselves and they bring in an arbitrator to assist them with that and to make a decision for them. Typically, arbitration is used in commercial contract disputes. For example, local authority may have a dispute with its builder over work done on its housing stock, or a bank may have a dispute with its software provider about deadlines not being met. Well, when the parties appoint an arbitrator, they are looking for someone who has expertise in their industry and expertise in relation to the particular dispute that they have. There are a number of key benefits for clients who decide to undertake arbitration to resolve their disputes. One of them is confidentiality. When you decide to arbitrate, both parties are agreeing that they will keep the matter confidential, so that's the fact of the dispute as well as the outcome. When parties decide to go to arbitration, they're picking an arbitrator who is aware of the commercial context of their dispute. So as well as having expertise in the particular area of dispute, they understand the commercial context in which they're operating. Perhaps they've come from the same sector. When parties decide to arbitrate, they can decide at the outset whether they will have an appeal against the decision that the arbiter has made. So they can decide one level of appeal or no appeal at all. And that's in contrast with litigation, where they would have a decision from a single judge, it could be appealed to 3 judges, and then could even be appealed onto the Supreme Court for 5 judges. And that can have significant financial consequences. Controlling the costs in any dispute are important, particularly to commercial clients. In arbitration, they can decide that there will be a cap on costs, they can decide that each side will bear their own expenses, or they can decide that whoever wins the arbitration recovers all the costs, and they can decide that at the outset. One of the great benefits of arbitration is that when the parties are situated in different countries, they can be confident that the arbitrator's decision can be enforced wherever they are. There's been a great resurgence in interest in arbitration in Scotland, and at Brodies we're particularly keen that clients should be aware of the benefits of arbitration, particularly since the new 2010 Arbitration Scotland Act came into force. At Brodies we have a number of people who are able to advise not just on the litigation side but also on the contract formulation, so that they can be made aware of all the options that are open to them when they write the contract. And when the dispute arises, we have people at Brodies who are able to take them through the dispute if they decide on arbitration.